And that was the testimony of Taylor Howard. He is the child of the victim, Melissa Howard, who is testifying at his mother's murder trial. We're going to bring in a former prosecutor and criminal defense attorney here in New York and New Jersey, Anthony Pope. Thank you so much for being here.
Oh, it's great to be here. Thanks for having me.
Our pleasure. So just, look, here's a young kid who was much younger at the time. It was 2006 when it happened. It must be incredibly difficult for him because here he has a situation where his mother has died. His father is not charged, but it does sound like his father may, in some of the testimony, have something to do with her death because he may have been involved in getting this guy to go to the house, although there doesn't seem to be proof of it. It must be incredibly difficult as a defense attorney to cross-examine this young man. How do you approach it? Do you get aggressive? Do you
have to play it by ear. I mean, going in there and showing dignity is always the best way. Start it off the right way, and then let him sort of set the pace as to how he's going to react to you. And if you see an opening and it's an opportunity for an inconsistent statement or an issue that you really have to raise, well, then you have to go at it. But you can do it aggressively but still maintain some level of dignity so the jury understands you're doing your job, but you're not a bully.
Yeah, no, look, I agree with you. I mean, some people require aggressive cross-examination. I'm not sure, especially, when we look at Taylor Howard, he's a really mild-mannered young boy, very respectful, and respectful to both sides. So I think you have to be careful. I guess the question, many people are asking is, this is a case that involves, DNA that was found quite a while later. And it sounds like the defense has an alibi, that alibi being that he was at a different place when this all went down. There isn't much other than the DNA and a wiretap, which we'll hear soon enough, that seems to indicate that he was involved, although some people question whether or not that's in fact true. Do you think people will have questions about kind of the missing pieces as to how the husband or the ex-husband has involvement, where he fits into the story, and do you think that may have an impact on finding this individual guilty?
Yeah, I absolutely. Listen, I have a graphic when I go to trial, and it's a puzzle, and it has all parts to it. And I tell the jury that they have to make the puzzle whole. If they don't do that, then there's reasonable doubt. So this is a case that does not have a lot of strong evidence. There's a lot of circumstantial evidence. So it's going to be a tough one for the prosecution, it would appear, from what I've read, and that's a little bit. But nevertheless, it seems like they're going to have somewhat of a tough road to hoe. And it's been some time since the actual murder taking place. I mean, the young man on the stand, I mean, he was the one they were fighting for custody for. Correct. So I mean, so there's not much I think he could really add to it. Just fill in a few different things. But I agree with you. Look, it's a puzzle. And at the end, on the summation, and you put that graphic up and you show the holes in it, the gaps, and you tell a jury that puzzle is not complete. And that's their burden, and that never shifts. So
yeah, I definitely think there's some pieces missing. And let's go on. I want to hear. Everyone to hear from Janice Burke. Janice Burke is the victim's divorce attorney who has some very interesting testimony to give to the jury. Let's take a look.
So that night when you spoke with her, what did she tell you was the reason that she was so upset?
The first thing that she said to me was, I knew this would happen. And I asked her, what did she mean by that? And she said that Brian sent one of his men over to scare me. And I asked who it was because, I asked who it was, and she told me who it was.
How did she identify the person that had done this?
Well, right after she had answered the phone, she said he just left. And then she said, I knew he would do this. I had made an assumption that it was Brian. That's why I said, who was it? And she said that it was Russell.
Did you inquire who Russell was referring to?
I already knew who Russell was based on our prior conversations. However, I did ask her to specify exactly who she was talking about.
Did she?
She did.
And what did she say?
She used his full name. She said David Russell.
Did she say what Russell told her during the course of the visit? I mean, why? How does that relate to what was going on in Melissa Howard's life?
That was the 4th of January, And beginning on January the 6th is when Taylor was supposed to start living with her on a primary basis. And she told me that what Russell told her was, you need to let that boy be with his father, and you need to let this go. So I took that to mean, of course, in 2 days, Taylor needed to stay with his dad as opposed to going to live with his mom.
So what we just heard is what I would consider is pretty bombshell evidence. This is the divorce attorney of the victim saying that the victim called her to tell her that she was very upset that Russell Holbrook had just been to the home and that he basically threatened her to give up the child custody case. I want to bring in again Anthony Pope to dissect this for a minute. You know, the judge had to make a ruling on this case. He had to decide whether or not it was admissible. And the argument from the prosecution was it's an excited utterance and therefore it should come in. And so first I want to get your take on whether, you know, your perception of what she testified to rises to the level of an excited utterance, if you have any thoughts about that.
Well, not based on what the attorney said. The way she presented it, I think the judge might have had a different view had he questioned her about it and had a hearing outside the presence of the jury. Now, maybe that happened, maybe it didn't. If it didn't, then he's basing it on the representation of the prosecutor. That being said, it could also be an exception to the hearsay rule because it's contemporaneous with the event as it's happening as well. So I'm not sure I would have relied just on excited utterance. I would have went with contemporaneous to the event happening as well. But either way, it's in now.
Right.
So therefore, the jury has it. So you may have to argue, somebody may have to argue it on appeal, but right now it's in the case.
Yeah, absolutely. Look, I mean, the point of an excited utterance is that it happens either contemporaneously, and the person is, in a sense, so excited that they're not going to have an opportunity to reflect and lie. And so, you know, the prosecution's point of view was that she had been crying, she was very emotional, and so one would assume that it had just happened. Obviously, it's not a federal trial, so it's the state is a little broader on what they view as an excited utterance.
And excited usually is, you know, an event that happens, it really catches you off guard, but it's a traumatic event. It's something a little bit different. But here, no question, I mean, it seems she wasn't expecting it. Right. And the fact that he comes to the house after the custody hearing and now she has custody of her son, it's a close call. But judges do that all the time, you know.
I agree with you. Do you think in any way, and we can talk about this when we come back, you know, I want you to think about this. Okay. Do you think that the fact that she was going through this big child custody issue might be a motive for her to even have lied to her attorney about what went down? We can talk about that in a little bit. We're going to take a break and we'll be right back.
We had radios, so I call it a beep beep, but my son asked me to, he wasn't there yet at that point, asked me to meet his friend because he didn't know where we lived, meet him at the little gas station on the corner. And so I drove down there, didn't get out of the car, just drove around, we waved at each other, and he followed me back to Beacons Bend.
How long would you say that trip took to get from your house to the gas station and back?
I don't know, 5 minutes, 5-10 minutes. I mean, it was just right down the road.
And that's the testimony of Brian Howard's present wife. She's talking about basically the day that Melissa Howard was brutally murdered, testifying as to the whereabouts of her husband, Brian. I want to bring in Anthony Pope and talk a little bit. Let's talk in general about alibi witnesses in general and kind of your thoughts about them, and then we can break this case down.
Well, you know, you have to be skeptical. Generally, they're people that know the defendant. So they have a motive or an opportunity or reason to possibly testify. I'm not sure about how far the direct examination is. I mean, if the direct isn't good, then forget about it. The cross is going to be devastating to the other side. But it appears as if she scripted. She has what she's saying she knows, but she's not always there. He goes upstairs. There's different holes in it. So depending on the cross-examination is going to really determine what the jury thinks of it. But going in there, when you have somebody who's associated, or a family member, or a wife, or a husband, the jury automatically is going to be skeptical about it. And if you have something to document it, you have a video camera, you have a restaurateur, you have the bellhop at the hotel, or the waiter at the restaurant that can verify what you're saying, or an easy pass or something that corroborates it, you're in a much better position than just putting this woman on. And I'm not saying she's lying, but just putting her on the stand to give an alibi. They generally don't carry the day unless they're really strong.
Yeah, you know, it's interesting because most times when we think of alibi witnesses, we think of the defense putting on the alibi for the defendant. Right. And in this situation, we are going to hear that, and because they're saying he wasn't there and he didn't have time to have gone there and committed the murder and gotten back. In this case, it's the prosecution basically having to disprove that other people could have done it in order to prove that he did it. And so it's unusual. I mean, one of the things I do note when I think about alibi witnesses as a prosecutor, I remember a lot of defense attorneys would put on multiple alibi witnesses. And the irony I always found is that even though potentially, I'm not saying they were being truthful, is they tend to step on each other. And the minute they step on each other, the jury starts to say, well, if they're lying, that means he's guilty, instead of if they're lying, it's just that he wasn't there, but it didn't mean he committed the crime.
Less is always better. Less is always better. You know, put on just what you need to put on to either prove or disprove the case. And beyond that, you just open it up to cross-examination and inconsistencies, and then it gets messy in front of a jury. And you know what it's like in front of a jury. Sure. I mean, it's a difficult thing. You really have to compartmentalize, and you really have to keep their attention all the time. So you start just bringing witness after witness, and it gets a little boring to them.
Do you think the prosecution may be in a better situation when they're making out the case in this situation to try to establish the motive through Brian Howard by saying basically, if we accept that the defendant went to the house and threatened him, let's build the evidence that shows that this was such an incredibly contentious custody battle, and Brian had the motive and therefore transferred over to Holbrook, and that way the jury's sitting there going, well, God, that motive is there, they're good friends, now we can understand why he's got the alibi, he doesn't, let's find him guilty?
Yeah, listen, you know, I hate second-guessing lawyers because, you know, a case has to get into your DNA before you really appreciate it and understand it and have that feel for it. But that was one of the things I was looking for when the attorney was testifying. I was looking for questions about how contentious it might have been. You know, how long did it go on for? Was it very heated? Was there really arguments on both sides going either way? And get a sense of, you know, Brian and how much he may have been upset by the loss, how much he loved his son, how much he thought he was the right parent, and now he's not the right parent for primary custody. So I agree with you, yes. That's the way I would have attacked it.
I agree. And look, I mean, unfortunately, we analyze everything, so we have to second-guess everyone. That's our job here. We're going to come back in a little bit. We're going to take a break. Thank you. And that's the testimony we're listening to. It's actually a deposition of the forensic analyst who basically went through quite a lot of evidence, and we'll eventually learn, you know, as we listen to this case, that there was no DNA of the defendant found on any items related to the death of Michelle Mockbee. I just want to bring in Anthony Pope very quickly. Anthony, we have a case where a woman was basically bludgeoned to death. We expect that there would be blood on the person that committed this crime or some DNA left behind. Is this a problem for the prosecution that there is no DNA whatsoever in this investigation?
Well, you know, everybody that watches TV watches CSI and they see DNA and they see the sophisticated techniques that law enforcement has. And when that's absent, now it's just a matter of who you believe. And do you believe an alibi witness? Do you believe the timetable? Do you believe there's a motive? So far, everything I've seen really is good for the defense, that's for sure. I mean, it seems like the jury's going to go to sleep on this, because why are you even putting it out there? I mean, she was bludgeoned to death. There's going to be blood. So do you want to emphasize the fact that you found no blood on the defendant?
I think you have no choice. I think as the prosecutor, you have to bring out, you have to cover your base. You can't let the defense say they didn't investigate anything.
But what's your explanation as to why you're bringing it out? Why are you, if you're trying to take the wind out of the sails of the prosecution, of the defense rather, that's fine. but there has to be something to tie it in. To just show the jury that there was DNA. Now, if there was male DNA under the fingernails or something of that nature, that comes out to the jury, but so there's male DNA.
I guess the question is if they did all their investigation and there's no DNA that's linked to any unknown person, then they can say to the jury, there's a reason, and the reason is because he left, got rid of the stuff, washed off really carefully, and then came back. That leaves room for the defense to say he didn't have the time that that he could have.
Exactly, and without bleach or without something. Look, there's many cases where they'll go into a house with a search warrant or a car, and when they search it, there's no DNA at all.
Right.
And that now is evidence. The lack of evidence in a case like that is supportive of somebody covering up.
Right.
But when you don't have
there's no DNA anywhere. You had to have been in that
you
car
go into my home and there's no DNA whatsoever anywhere. I mean, that's the best evidence you'll ever get, because that's clear now. Somebody went in there and purposely destroyed all the DNA. But in this instance, I understand your point as prosecutors. You have to cover your bases. I'm not sure they're getting anywhere with it, though. I don't think it's going to help in the end.
We certainly will see. We're going to take a break, and we'll be back with more testimony. And I'm going to be signing off, and next you're going to be hearing from Aaron Keller, who's going to be doing the Daily Debrief. I believe you're going to be talking a bit about the Jussie Smollett case. There was a recent arrest that obviously doesn't surprise any of us, at least certainly not many of the attorneys that have been following this case. So I think it'll be a super interesting thing to talk about.
Yeah, it's an interesting case, that's for sure.
You've been following it?
I have, yeah. From day one, it didn't seem right. It just didn't seem right. You know, two people that want to do such harm to someone and who walks away with a scratch on his face. You know, it was a little bizarre. 2 o'clock in the morning, sub-zero temperatures out there, and all of this happening. I knew something was wrong. I wasn't sure exactly, but I remember saying to someone, I said, this case just doesn't have a ring of truth. Yeah. I said, I can't put my finger on it, but there's something missing here. So it wasn't a surprise. It wasn't a surprise.
I think what's interesting, if anyone who's been following it, I think they should go back and look at the interview he gave, because when you put it in now in the context of what we know, it really, you see quite a, in a sense, a snow job in terms of that. So we're going to be breaking that down with Aaron Keller, and then Brian Ross Investigates at 5:30. Thank you.